We are now recording. Welcome to Courts in the Judicial Process. Today is Tuesday, April 14th, and we will start today with pretrial procedures. What I want to mention to you before I start and move over to the PowerPoint and some of the videos is I am running on generator due to power loss, trees down, roads closed, etc. So if you lose me, my generator is really good, but they're shutting off different points in order to reconnect all the wires around. So if you lose me, don't panic. I will jump. You shouldn't lose me, but if you do, because of a connection, I will jump right back on. So don't go anywhere. Okay. All right, so let's see. All right, so in this chapter, a lot of what we've been learning, reading about, talking about comes together in a step-by-step process. And so there's a lot here, a lot of detail here, but the structure, the roles, the responsibilities, the adversarial system, the what else am I trying to think of? The discretionary decision making that we've talked about by prosecutors and defense attorneys and judges all manifest themselves pretty clearly here. So we're going to have two classes on pretrial procedures today and Thursday. Then we will move to trials, jury trials and trials, and then our last class will be on appeals. So we'll take it all the way through. So here are the details of what I'm asking you is to understand the steps in the criminal justice process and who does what when and why and how each step builds upon the other. And each step is an opportunity for the defense to challenge the government's case. And we'll talk about that and see how that works. So we'll start with the beginning. We'll talk somewhat a little bit about booking and what happens at the booking process, then charging, then arraignment, which in Massachusetts we call that first court appearance and arraignment. Other states call it an initial appearance. It means the same thing. It's the first time a defendant steps foot into a courtroom, having either been arrested or in some cases indicted by a grand jury in a criminal case. Then we will move from there to talk about the different, at arraignment, one of the most important things that happens is if there is probable cause, and the judge generally finds that there is, it makes a very cursory determination based upon the police that there is probable cause for the arrest. And then the issue becomes, okay, is this person who is now before the court formally charged with a crime going to be able to leave here today? And if so, will he or she leave just on their verbal promise to come back? Will he or she leave on their verbal promise, but in addition have some conditions that they will have to comply with and maybe even report to probation, although they haven't been found guilty of anything? So that's called release on own recognizance, with or without conditions. The second option at arraignment is if the prosecution asks for bail, then the court can determine whether bail is necessary, given that the purpose of bail is to reasonably secure the defendant's next appearance in court. And we'll look at the factors that go into, at least in Massachusetts, and they're not different really significantly from other states, the factors that the prosecutor argues and that the judge can take into consideration to determine, is this case one that requires bail? And if so, why and for how much? And again, if bail is, that's a discretionary decision by a judge. If the judge does require the defendant to post bail, and there are three different bail systems, we have a cash bail system in Massachusetts, and I'll talk briefly about the other systems as well. But then either defendant can post bail. The prosecutor may be asking for some conditions of release in order to increase public safety and also reduce the likelihood of a new offense while the defendant is out on bail. The third option is the prosecutor can request something called pretrial detention, which is, I'm not worried about whether this person's going to come back to court or not. My concern is public safety, that this individual poses such a risk of safety to either an individual or multiple individuals or the public at large, that there are no conditions of release that can adequately secure public safety. Therefore, the prosecution moves to have the defendant held on pretrial detention. And that, in Massachusetts, requires a hearing. It's really like a mini trial. And the standard is quite high. It is clear and convincing evidence, which is higher than probable cause, lower than proof beyond a reasonable doubt. And that's the last thing that a defendant wants to have happen, but it does happen routinely in first-degree murder cases. So when Aaron Hernandez was first arrested, although he didn't have much of a criminal record here in Massachusetts, the prosecution moved for pretrial detention, and the court granted the Commonwealth's request. Mr. Hernandez was held without bail on pretrial detention under the Massachusetts pretrial detention or preventive detention statute, and he remained in jail until he went to trial, and then when he was found guilty at trial, he moved from jail to prison. Okay, then the next thing we'll talk about is, we'll talk about the plea bargaining process, the rights the defendant gives up, the impact that pleading guilty has on a sentence compared to conviction after trial, and then we'll move forward from there. Okay, so we're going to begin. Pretrial procedures. The pretrial process is on that. Hopefully you have a good, clear, large, readable copy of this particular picture that you see here. Pretrial process in a criminal case is everything up to the line, the blue line after the word, indictment. And then we move from entry into the system. That's the beginning part, 3 steps. After a crime has been committed, there may be a criminal investigation. Unless the police observe the offense, there probably will be an investigation. It could be lengthy, it could be short. If the police, law enforcement develop probable cause to make an arrest, the second step in stage 1 is the arrest of the defendant. The defendant is then taken into, the arrestee is taken into custody, booking occurs, and then depending upon what state you are in, the next step after booking is formal criminal charges are lodged against the defendant. In some states, only the prosecutor can file those charges, and therefore at that point, in a state that requires the prosecutor to file the charges, the case moves from stage 1 to stage 2, which is prosecution and pretrial or services and process. In Massachusetts, our police are permitted by law to file the charges, and they generally do that so that by the time that the defendant makes his or her first court appearance in court, the charges have already been filed and they'll be reviewed by the prosecutor. So we're talking pretrial is actually everything up until the trial. And many cases won't get to trial because of the things that happen along the way, including these additional steps like pretrial motions and plea bargaining. Oftentimes cases resolve at that point, which means there's no need for a trial. You skip the trial. The next step would be sentencing. So that's our journey, but we're going to have a lot of detail along the way. So 6 stages: entry, prosecution, and pretrial services or pretrial proceedings, adjudication, judicial procedures. The courts are involved in all of this. And then if there is a conviction, either by plea or by trial, then it moves to the corrections phase and then to the post-conviction relief or appeals. And we'll see that there are after conviction, there may be some things that a defendant can do before the trial court, as well as the defendant obviously has the right to appeal, and we'll talk about appeals in Chapter 13. Another step that is possible that we will also discuss in Chapter 13 is something called habeas corpus, which is another post-conviction legal recourse that a convicted defendant can take. Okay, each stage, has several steps. At the outset, I want to remind us all that the steps that are listed on the original photo that I gave you include a step 6, 7, and 8. Those steps, 6, 7, and 8, only apply in they only apply in federal or state cases that involve a serious felony, or in the federal system, every federal criminal case is entitled to all those steps in the process. In Massachusetts, only those cases where they can only be tried in a court of original general jurisdiction, like the Hernandez case, because the sentence in that case would be state prison. Those serious felony cases have to have additional steps in the process to get Mr. Hernandez in his case from the court of original limited jurisdiction, Attleboro District Court, where he first was arraigned following his arrest, and then ultimately to the Bristol Superior Court, where he went on trial. So I'll talk, when we get to this point in the steps in the process, I'll talk about the different models. Some states, like Massachusetts, do have a grand jury requirement, but that requirement only applies here in Massachusetts, and in many states that have grand jury requirement, that's a matter of state constitution. The right to a grand jury in a federal case has not been incorporated into the 14th Amendment, and therefore state defendants have no federal right to a grand jury. That right exists only to the extent provided by law in the state. Okay, stop, pause, question. Anybody have a question? I hope you have lots of questions as we move forward. It will make it a lot more interesting. And if you don't have any questions, that suggests to me one of two things. Either you already know all of this, in which event you shouldn't be taking this course, or you haven't really engaged with the material well enough to be able to formulate a question, and that would also not be a good idea. But on we go. Okay, so stage 1 involves the whole process, the criminal justice process as a whole, from the commission of a crime, or actually an arrest of an individual, an investigation that results in arrest, all the way through to appeals or habeas corpus petitions. All have due process rights that state, federal, and local government must respect. 4th Amendment, 5th, 6th, 8th, and 14th Amendment. So early on in stage 1, step 1, the investigation, law enforcement may be stopping an individual on reasonable suspicion, frisking an individual on reasonable suspicion that the person validly stopped has or may be armed and dangerous. A search of a person, which requires, as you hopefully remember and have learned in other classes, probable cause and a warrant, a search warrant or a warrant exception to search or seize. Those actions all may take place before an arrest even happens. Sometimes they take place after an arrest. So the 4th Amendment applies to stops, frisks, searches, seizures, and arrests. The 5th Amendment applies to arrests, interrogations. 6th Amendment applies to arrests, interrogations, identifications. In some instances, as you remember from Chapter 6, when we talked about defense attorneys, there's no right to a defense attorney unless the defendant asks for one at a post-arrest custodial interrogation. There is a right to an attorney at all court proceedings, but not all post-conviction proceedings. Okay, so the courts are there along the way, and the defendant, through counsel, is going to challenge any of these things that take place, all of them, as often as he or she can. They will challenge what the government, law enforcement, in the case of the investigation aspect of the crime, which would be everything identifications up to stops, and everything that the prosecution does in pretrial and trial procedures are all fertile ground for a defendant through counsel to challenge that the legality of the government action, whether it's the prosecutor or law enforcement or the judge in the case could be. That's how cases get resolved in favor of the defendant, is really a vigorous, zealous representation of a defendant, challenging everything that's reasonably challengeable and testing the government's case all along the way. Okay, so these are just a reminder. I'm not going to go through these, but we worked in like in the third meeting we had together, we worked on looking at it, understanding the big picture and the puzzle pieces of the three component parts of criminal justice, the level of government at which they exist, and what parts in the criminal justice process were law enforcement involved with. So as we've discussed before, law enforcement exists federal, state, and local level, always part of the executive branch, and their responsibility, their role and responsibility is primarily during stage one, entry into the criminal justice system, step one, investigation, step two, arrest, step three, booking. In states like Massachusetts, law enforcement are also allowed to make those initial charging decisions. But even then, the prosecutor is responsible for ultimately determining what the charges will be. So once we're at this point, we're in the second stage of the process, prosecution and pretrial services. This is where the prosecutor and the defense attorney begin to have or represent their adversarial interests. We'll talk about the initial appearance, which we call an arraignment. We'll talk about states that require a preliminary hearing versus a grand jury indictment. And that's all part of stage two. Once a person has been indicted, if it's a case, if it's a jurisdiction that requires a grand jury indictment in order for the case to proceed, then it moves to adjudication and judicial procedures, stage three. If the case is in a state that does not have a grand jury requirement for serious felony cases, but requires instead a preliminary hearing, then if the government survives the preliminary hearing, then the case moves on to stage three. And as mentioned earlier, a lot of stuff happens in stage three that often results in 95% of the time, results in the trial not having to happen, either because the case was dismissed, because of pretrial motions to suppress evidence, or other pretrial motions, or because the case is plea bargained and the defendant, having pled guilty and waived all of his or her constitutional rights, stands guilty before the court, and the next step would be we jump over trial and go to sentencing. Okay, so that should be all a good review for you, a refresher. Corrections obviously only comes into play post-conviction, except for those situations where someone is held has to be under conditions of release, either on recognizance or on bail. And let's see. And yes, as I mentioned, Chapter 13 will talk about Stage 6, which is post-conviction, meaning after conviction. Relief, meaning asking for the court to do something, to correct something. And that includes appeals as well as habeas corpus petitions. Questions? Oh, Maddie, do you have a question? No? Okay. All right. Again, another review. Adversarial system. This process is adversarial. The government's represented by the prosecutor, the defendant's represented by the defense attorney. Their opponents, they have different jobs to do. We talked a lot about the roles and responsibility and ethical parameters and guidelines and standards governing the conduct of prosecutors as well as defense attorneys in chapters 5 and 6. The judge in this system is supposed to be impartial. We talked about when judges may not be impartial and how that might impact the validity of a conviction. A judge, in fact, is determined on appeal or on a petition for writ of habeas corpus to not have been impartial. And we looked at a case in chapter 7 where just that same thing happened. Both sides have an opportunity to present evidence through testimony, witnesses, physical evidence, they're called exhibits. The government must present a sufficient case to prove at least a prima facie, on its face, proof beyond a reasonable doubt that the defendant committed whatever the crime is or crimes he or she is charged with. The defendant has no responsibility to present any evidence at all. In fact, there's no burden on the defendant at all, with the exception if the defendant raises something like an insanity defense or self-defense. There may be the landscape on that might change a little bit, but as a arch principle, the burden is on the government. The level of proof is proof beyond a reasonable doubt, and the defense has the right to challenge all of the government's evidence and witnesses through cross-examination and to call their own witnesses, which we'll talk about how does a defendant get people to appear in court in a criminal case when the case goes to trial. And we'll talk about that in chapter 11. Okay. Lots of rules that govern the criminal justice process. Those rights to due process under the 4th, 5th, 6th, 8th, 14th Amendment. Then we will see when we move into the trial phase, rules regarding admissibility of evidence, rules regarding who's qualified to testify as a witness, lots of different rules, court rules, constitutional rules, rules of evidence, all come into play, and the judge is the referee to make sure everybody's playing by the rules. Remember, legal guilt requires proof beyond a reasonable doubt. Legal guilt is not the same as factual guilt. Someone can be factually guilty. They committed the crime, but they are found not guilty of the crime with which they are charged because the government failed to prove everything it needed to prove beyond a reasonable doubt. Okay, questions? Anybody? No? We good? Moving? All right. So we have the prosecutor, the defense attorney, the judge. They have different roles and responsibilities. And the pretrial and pre-arrest, the judge is involved with or could be involved in determining whether or not to issue a search warrant or an arrest warrant. At that initial appearance, what we call an arraignment, the judge presides over those proceedings. If the case is in a state that does not have a grand jury requirement, the judge presides over a preliminary hearing, or what we call a probable cause hearing in Massachusetts. As the case moves forward, either post-indictment by the grand jury or a finding of probable cause at a preliminary hearing. Then the next step, as we will see, is an arraignment this process is for serious felony cases. The second arraignment is in a court of original general jurisdiction, and then it goes on from there. Okay. Let's see. We're going to try this. Hang with me for a second. I think it's going to work. Hold on. Can you see the? Are you seeing the screen that says criminal justice introduction with a gavel? Do you see that? Yes or no?
Yes.
Thank you. Okay, so this is
make decisions about whether to pursue criminal charges. The prosecutor is one of the most powerful people in the criminal justice system. Prosecuting attorneys make decisions about whether to pursue criminal charges, when to plea bargain, and what sentences to recommend. Their decisions are generally not subject to second guessing by higher authorities. They can be considered the gatekeepers of the criminal justice system, as they control which cases come into and which fall out of the system. After completing this learning module, you will be familiar with the types of prosecutors at different levels of the criminal justice system, and understand the relationship between politics and prosecutorial decision-making. There are prosecuting attorneys at the federal, state, and county levels of government. The U.S. Attorney General, along with assistant U.S. attorneys, prosecutes federal crimes in the 94 federal district courts. An attorney general is elected for each state. However, most cases are processed at the county government level by prosecutors that go by different titles, depending on the state. The most common titles are district attorney, state's attorney, commonwealth attorney, or county attorney. To the surprise of some, politics play into the prosecutorial role. County prosecutors are elected in all states except Connecticut and New Jersey. This creates potential for decision-making to be influenced by the will of voters instead of pure legal principles. For example, prosecutors may aggressively prosecute sex offenders by refusing to plea bargain, yet ignore violations such as minor drug possession. Although both are violations of criminal statutes, the political climate influences when and how prosecutors exert authority.
okay. What's the answer? Most prosecutions are processed at which level of government? What's the right answer? Someone needs to answer.
Is it state?
That is correct. Far greater number of state criminal cases than there are federal criminal cases. So, and cities and counties don't prosecute. The charges are on the behalf of the state. A county and city towns are political subdivisions of the state. So it was either federal or state, and there are way more, millions more, literally millions more state criminal cases than federal. Good job. What is the likely outcome if a prosecutor makes a decision not to prosecute a case, a decision that is generally unpopular? Can the prosecution's decision to dismiss be overruled by a judge? Yes or no? This is a review from chapter 5. Yes
No.
or no? Pardon?
No.
That's correct. The answer is no. It is within the authority of the prosecutor to decide whether to charge, what to charge, whether to dismiss or not. Is B correct? A county prosecutor's decision to dismiss can be overruled by the most senior elected official in the county. True or false? Obviously, it's false. If the judge can't overrule, how could somebody who's not a member of the court work group overrule? Can the governor overrule a prosecutor's decision? The answer is no. It's not reviewable in most states. It is considered to be the sole and exclusive authority of the prosecutor. Okay, we're going to have to talk about that. Prosecutors, would you describe them based upon what you know as the gatekeepers, the wardens, the troublemakers, or none of the above? What do you think best describes the prosecutor understanding what his or her role is in the criminal justice system and process? Anyone?
The wardens?
Nope. I mean, they are to a certain extent because they prosecute cases, and if there's a conviction, they make a recommendation, but the judge decides. Warden infers corrections, jails and prisons. But that's a good guess. They're actually the gatekeepers because they have the power to decide who to charge, what to charge, whether to dismiss. They are the gatekeepers. The more people they charge, the gates get wider and more people come in. The more cases they dismiss, the gate gets smaller. So they are thought of as opening and closing the door to the criminal justice system. Okay, we're not going to cover that. All right. Let's see. Okay. Okay, we're back, or should be back. Hang on one second. Okay, yeah, so this slide and the next slide really just relate to what you just watched, and that should be reviewed chapter 5. And so I'm not going to go through all of that. A quick refresher, the defense attorney's job is not to find the truth. It is not, unless the truth is that the defendant did not commit the crime. Defendant through counsel is not required to present any evidence. It's not the defense attorney's responsibility to prove the defendant's innocence. In fact, there is no proclamation of innocence in a criminal trial. If the prosecution fails to establish guilt beyond a reasonable doubt, the defendant is found not guilty. The defendant is never found innocent in a criminal trial. Okay. So we've covered in chapter 6, the roles and responsibility of the defense attorney will become very important here in pretrial proceedings because it's those motions to suppress evidence, motion to dismiss, making sure that he or she gets all of the discovery material and participates in plea negotiations if appropriate. And all three of those things happen during the pretrial process. Advising on whether to go to trial or take the plea, preparing the defense, hiring experts to do investigation to counter the evidence that the prosecution has. And then from that point on, that's going to be trial decisions. So the defense attorney is always trying to get the case dismissed If they can't get the case dismissed, they want a plea bargain and get the best deal possible. If they go to trial, obviously they want to not guilty. And if the defendant is convicted, their goal is to try and have the least harsh punishment as possible. We've talked before about discretion. All of the players in the courtroom work group, sorry, I blew by something that I wanted, are involved in making decisions. And we're going to quickly watch a piece on that. Okay, you should see another criminal justice introduction block there. Everybody see that? Is the screen projecting correctly?
The entire criminal justice system is shaped by decisions made by individuals working in the system. Police officers, prosecutors, probation and parole officers, judges, and even correctional officials make decisions every day that shape the experience of those accused of crimes. Each of these entities is an important part of the system of criminal justice. You can click the buttons here to see the percentages of criminal justice employees at each level of government.
So less than, or just with the exception of courts, less than 10% of all the people that work in the criminal justice system, or 10% of all law enforcement in this country are federal law enforcement officials. Only 4% work for the Bureau of the Federal Bureau of Prisons, and about 12% of all the judges and prosecutors in the country are on the federal side. The state side obviously consumes most of the judicial branch, corrections, and in total, they are just about 10% of law enforcement in all the country is state police. And then when we move to local, most obviously.
After completing this learning module, you will.
Sorry. Sorry about that. Okay, so I'm not sure how far we're going to go with this, but let's see.
Every individual in the criminal justice system has a high degree of autonomy about how to carry out his or her daily tasks. That may be a surprise for many of us who think of the criminal justice system as being shaped by laws that are, for the most part, black and white. The Constitution, legal statutes, and other rules of governance establish with a fair level of clarity what behaviors are prohibited and how the criminal justice system is supposed to operate. In reality, the ways these laws are applied are substantially more complex. For example, have you ever heard someone say, "Don't worry about speeding a little. Police in this town don't pull you over unless you're driving 5 miles an hour over the speed limit"? This exemplifies a reality in the criminal justice system. Police and other decision makers are given a wide range of discretion about when and how to invoke their authority. Discretion could be considered the most important characteristic of the criminal justice system. It is widely accepted that discretion is exercised in every facet of the system. One example of discretionary behavior is what police do when they respond to a 911 call. Officers weigh the credibility of victims and witnesses, apparent injury or harm, and evidence at the scene to determine if a crime has occurred and if an arrest should be made. If an officer believes no crime has occurred, he or she has the authority to consider the event as unfounded, a classification that stipulates a crime never occurred. In other cases, officers may consider the event to be founded and record it as an official crime by generating a police incident report. These reports then become the basis for subsequent crime statistics. However, this is not the end to crime reporting. Police incidents and arrests amount to little more than recommendations to prosecutors who have the legal authority to accept or dismiss criminal petitions. If accepted, prosecutors initiate the court processes. If dismissed, cases are dropped. leaving the victim with little legal recourse.
Okay, we're going to leave there and go back to, excuse me. Excuse me. Anybody have questions yet? No questions, you guys. I don't know what you're doing. Okay, so we've covered discretion before, and for those of you that were helpful when we did review the James Bauer story, his journey, his story, step by step, walks us through the criminal justice process, the different stages, and the different steps. Some things that I want to remind us all about as we move forward. We're talking about the criminal justice system here, not the juvenile justice system. So in every state, there is a process for criminal proceedings against juveniles. Juveniles now in most states, including Massachusetts, is anyone who engaged in an action before his or her 18th birthday that would be considered a crime if committed by someone was 18 years or older. The juvenile justice system is designed to be more rehabilitative and less punitive. But there are processes in every state, including Massachusetts, by which an individual who's younger than 18 can be prosecuted, tried, and punished as an adult. In Massachusetts, it is called the Youthful Offender Statute, and therefore we do see individuals as young as 14 years old being stepping into and going through the adult criminal justice process, and if convicted, being punished in state prison. Other states have what's called a transfer hearing process. And I mention that only to be clear that what we're looking at here is the adult criminal justice, not the juvenile justice process, which is different. So reminders, many stages, 6 to be exact, many steps from beginning to end. Cases drop out of the process all along the way. That you might remember is called case attrition. The criminal justice funnel, which is wide at the top but narrow at the bottom, is represented or depicts the idea that the funnel, a lot of cases come in, but not many come out the bottom, at least compared to the number that came in at the top. I also need to alert you that the courts are now operating under, as we all are, under physical distancing and safety, public health warnings, which means how do we provide justice in the absence of having somebody come before a judge? So the Zoom justice is we've got going on now. A lot of courtrooms are using Zoom remote sessions, not unlike what we're doing here, but there are some real concerns about whether or not the technology, which, as you know, is not perfect. We've learned that. I certainly have. And the rules differ from jurisdiction to jurisdiction how that technology is used. And it's not clear that in this process, defendants are getting the same due process rights that they would if they were not being live recorded before a judge. Obviously, it's hard to confer with your attorney under these circumstances. So something to be mindful of that, and at the same time, there's been no delay in deportation proceedings against immigrant children who are here not legally, and so it's rather interesting that those hearings continue and some of the criminal justice stuff is not able to continue. There's no trials being held to the best of my knowledge. They're all on hold, at least in Massachusetts. There have been hearings, motion hearings, arraignment sessions, but those are remote. The trials have not been in. I don't think they will be allowed to be, frankly, here in Massachusetts, although I could be proven wrong. Okay, here we go. Oops, back. So the criminal justice process, stage 1, 2, 3, 3 and 4, sorry, 5 and 6. Remember, only serious felonies get those steps 6, 7, and 8. Misdemeanor or less serious felonies in Massachusetts, that means any case that's not going to receive a state prison sentence if the defendant is convicted, skips those 3 steps in the process, and we'll talk about why that is. This is maybe a little hard to follow at first, and I'm not going to go through the whole thing, but it's a decision tree. So it takes you through the process by which either a case is started with an arrest because the police observed the crime, or they didn't observe the crime. They have to make an investigation, and then they may develop probable cause to make an arrest. This shows you all the different decision points along the way, and it's a different way of looking at and understanding better that the steps in the criminal justice process depend upon what happens at the step prior to it. So that's what that's there for. Okay, so an investigation, first of all, a crime has to be reported or observed for there to be an investigation. If there is no reported crime, and many crimes, a significant percentage in this country, depending upon the type of crime and the specific type of crime, property crimes have a lower than 50% report rate, which means that if we only looked at police reports or the number of police reports to determine how much property crime was being committed in the country, we'd get a very different picture than the reality. And hopefully you remember from your crime theory course that an important source of crime data is not just to look at police reports or arrest reports or court records, but to ask individuals. And that's why the National Crime Victimization Survey is so helpful in helping us to see that dark figure of crime, all the crime that happens that victims say, yes, that happened to me. Did you ever report it to the police? No. So if they've never reported it and the police have never seen it, it doesn't mean the crime didn't happen, but it does mean the case is not going to enter the criminal justice system or process. Okay, reminder again, if there's an arrest, and generally speaking, we do have arrests. Occasionally the arrest occurs after a grand jury indictment, but more often than not, the arrest occurs prior to. That arrest, in order for it to be legal, has to be based on probable cause and an arrest warrant or a warrant exception. If an arrest is made and there was no probable cause and a warrant or a warrant exception, it's an illegal arrest. And anything that happens after that illegality is going to be subject to a motion to suppress, which means if they make an arrest and then they search the person, which they typically do, and they find evidence on the individual immediately following the arrest. Typically, well, not typically, an exception to the warrant requirement to search is a search that immediately follows a valid arrest. But if the arrest isn't valid, then the search of that person in the area, the lunging area within which the person could be reached at that moment of arrest, then whatever they find in that search will not be admissible in evidence. So from the very beginning, there are due process rights that have to be adhered to, and it's the job of the defense attorney to figure out, is there valid legal grounds to challenge the arrest? Because if there is, some good's going to come from that from the defendant's perspective. Okay, booking. Booking happens again in stage 1, but it's step 3. This is always done by law enforcement, federal, state, or local. It is it's creating an administrative record, a formal public document indicating that the government, federal, state, or local, depending upon who the law enforcement agency is that committed um, that executed the arrest, that the government has a record of taking someone's freedom and liberty away, and who are they? That person's going to be subject to an inventory search, which is a search warrant requirement. So if they arrest someone and bring the person, let's say they've got their car, if the arrest occurs on a public way, and it's quite likely that there's a policy that allows that car defendant was driving to be towed to the police tow lot where it can be searched to make an inventory of everything that's in the car, and that's a search warrant exception. The defendant can be asked, and is asked, identifying information, name, address, date of birth, aliases, mom's name, dad's name, all kinds of information. That kind of non-testimonial identifying information is not protected by the Fifth Amendment right against self-incrimination, and therefore a defendant does not have the right to say, I'm not going to tell you my name or my birth date or my address or my mom's name or my social security number or anything else. Individuals can be photographed, and they do not need to consent to be photographed. They can be fingerprinted. Consent is not required, and typically allowed to make a phone call at the time of booking. So that's handled by the police. Then in Massachusetts, the police do typically, either state or local police, fill out the criminal complaint, which is the charging instrument advising the person who's been arrested, you are being charged with the crime of fill in the blank, assault and battery with a dangerous weapon in violation of Massachusetts General Laws, Chapter 265, Section 13, whatever it is, or 15, whatever it is, that occurred on whatever the date was and in whatever the place was. So the charging document is prepared by law enforcement in Massachusetts. In other states, it is not. The charging document does not get prepared until the case comes into court, and then the prosecutor is the one that makes those decisions. Okay, so there are 3 different types of charging documents. If it's prior to a grand jury indictment, but post-arrest, it's called a complaint. And if it's a post-grand jury indictment, it's called information. I'm sorry. In states that do not have a grand jury requirement, it is called an information. And if the charging document follows an indictment, the indictment is called a true bill, and I'll talk that shortly. True bill of indictment, which is required in less than half of the states. Massachusetts does require an indictment or a true bill to issue by the grand jury in any case, which is punishable only by state prison time. If you have questions, please stop me. Okay. In some states, as I mentioned, only the prosecutor can file those criminal charges. In Massachusetts, in some states, it's called a complaint. In other states, it's called an information. Regardless, and even in states like Massachusetts, the initial charges by law enforcement stated in the complaint are subject to review by the prosecutor to determine whether or not there is sufficient probable cause and whether or not there are charges that are missing or charges that should be dropped. If no charges are filed, the suspect, in other words, if the police arrest and file a complaint and the prosecutor reads it and says there's no probable cause here, the prosecutor has a duty to dismiss the charges before the before the person is arraigned in court. Okay, so whether it is by complaint or by information, unless the person has been, unless it's after a grand jury indictment, the first step in the first courtroom step in the process is called an arraignment in Massachusetts, or initial appearance. This is before a judge. In federal cases, that initial appearance or arraignment is before a clerk magistrate, who is not a judge but is an attorney that handles that first court appearance. Okay, very important things happen at that first court appearance, which we call an arraignment. We're going to listen a little bit about that right now. But before I switch over, anybody have questions so far? Am I going at a pace that you can follow, or am I going faster than you would like? Okay, too fast. Which is it?
It's okay for me.
And anybody, just raise your hand if I'm going too fast and you want me to slow down.
Do criminals have too many rights? While public opinion is sometimes mixed, there tends to be a general impression that the criminal justice system values the rights of those accused more than the rights of victims. The pretrial arraignment represents the beginning of the formal court process, and is also when the impact of legal protections really begins to surface. After completing this learning module, you will understand the major steps in the pretrial process, and recognize the potential conflicts between the goals of due process and crime control. The pretrial arraignment functions to make sure the rights of the accused are protected. Prosecutors and judges review available evidence and dismiss unwarranted charges. Defendants generally appear within 48 hours of a warrantless arrest to hear charges filed against them. The judge also ensures probable cause exists to believe a crime has occurred. Finally, defendants enter a plea and are considered for bail. These are all critical steps in court processing. In the 5th and 14th Amendments, the Constitution affords due process protections to those accused of crimes. It does not provide explicit protections for victims of crimes. Some argue that courts have put the public at risk by liberally interpreting the Constitution and giving accused criminals too many legal protections. There are many examples where the goals of due process seem to conflict with the goals of crime control. For example, should evidence that shows the guilt of the accused be admitted when the evidence was obtained illegally? If yes, then what are the limits to government power? If no, then what if this means a child molester goes free? The implications of either answer are profound.
So you see, again, we are heading towards the end of our journey in this course where we started, which is thinking about the cost benefit of having due process protections, and whether that advances or frustrates either the crime control model or the due process model. Okay, I'm going to stop there. So I'm now going to cover in some detail what happens at the arraignment. And I'm on slide 72. Yes, Justin.
Yeah, I was just wondering, when it comes to people who are detained people who are arrested,
Yeah.
is it common for when someone's arrested for that case to be thrown out there rather than in court? Or is it more
No. Dismissal of the charges would occur at the discretion of the prosecutor. So no, it would. The police have discretion whether or not to charge, but if they decide to charge, it's then the prosecutor's responsibility to review the information that's in the police report, and perhaps even interview the relevant witnesses to determine whether or not there is probable cause. And if there isn't, then it'll be dismissed, hopefully by the prosecutor, and if not, then the defendant's attorney will request will make a motion to dismiss and ask the judge to dismiss it.
Okay, so it would never come down to like someone's writing on a police report and realize they made a mistake and they wouldn't. It would
Well,
always
no,
go.
writing out the police report, it depends upon whether the police report gets written before or after someone's arrested. Once a person's been arrested, the police can decide not to file charges. But if they file charges, only the prosecutor or the judge can dismiss them.
Okay.
Okay? Am I answering your question?
Yeah, yeah. No,
Okay.
that's helpful. Thank you.
Okay. All right. So 5 things happen at an arraignment. We call it in Massachusetts. It's called an initial appearance in other courts, and it is confusing because it's confusing for the following reason. In a serious felony case, the defendant, like Aaron Hernandez, who's arrested, is brought into court and arraigned. Then his case goes, because it's a serious felony, his case is brought before a grand jury. The grand jury indicts him, and then he's arraigned a second time. The second time it's in a court of original general jurisdiction. The first arraignment is in a court of original limited jurisdiction. So that's why states other than Massachusetts differentiate and use preliminary hearing or initial appearance rather than arraignment. So the first thing that happens at an arraignment is the defendant is informed of the charges, as is required by the Sixth Amendment right to notice of charges against us. In other countries, individuals can be detained, arrested, and held without ever knowing what they've been accused of. We have a right to a notice of the accusation of the charges against us, and that has to occur at that initial arraignment. The defendant has a right to counsel, and if he or she, unless he or she is going to waive counsel, then the defendant has a right to court-appointed counsel if the court determines that the defendant is indigent. Once the defendant either has counsel because he or she has private counsel, or the arraignment is suspended for the appointment of counsel, which is usually someone, depending upon the system of public defenders in what state you're in. In Massachusetts, it would be an appointment of whoever was on the list that day of the attorneys that happened to be in the courtroom that were scheduled to take and pick up any new arraignments that occurred there. Then the defendant could talk to his or her attorney. The arraignment would then continue. The defendant would enter a plea. There are 4 plea possibilities: not guilty, guilty, nolo contendere, and not guilty by reason of insanity. Obviously, if the defendant decides, with advice of counsel, to plead guilty at that moment, then this is going to be a very short criminal justice process, because the judge, if the judge accepts the guilty plea, is going to then sentence the defendant right then and there. And if it's a minor case, if it's just involving payment of fees or fines, that can happen at the arraignment. Anything that carries the potential of any or the likelihood of any incarceration or even probation, probably the best thing to do is to plead not guilty. Nolo contendere is a plea that is available to a defendant, which basically says, I'm not going to plead guilty, but I'm not going to contest it either. I admit that there's sufficient facts on which I could be found guilty. And the advantage of a nolo contendere plea is that it cannot be used in a civil case. And that's the only advantage. If someone pleads nolo contendere, which is Latin for I don't contest it or no contest, then the next step in the process would be sentencing. Okay, very important that happens at the arraignment is the judge has to determine whether the defendant's going to be released or held. If the defendant is released, will the defendant be released on his or her personal recognizance, which means a verbal promise, I will make all my court appearances? Or will the judge say, I will release you, but you must post bail? Or a third option is the judge can make a decision, I'm not going to release you, I'm going to hold you without bail, either on a dangerousness hearing or for other reasons that I'm going to talk about in just a minute. The next thing that happens, I'm going to come back and talk a lot more about the bail decision. The last thing that's going to happen at arraignment, once the decision of am I going to release on personal, am I going to release on bail, or am I going to hold the person? The last thing that's going to happen is the defendant will get a next court date, and we'll talk about what that is in a minute. Okay, in the case of a serious felony, the next court date would be, depending upon what state the person was in, either a preliminary hearing before a judge to determine whether there is probable cause, or a grand jury hearing. If the case is not a serious felony, in other words, it's not only punishable by state prison time, then the next step after the initial arraignment is going to be the pretrial conference, skipping 6, 7, and 8 and jumping to 8A and 8B. Okay, so you know about counsel, appointment of counsel. We covered that in Chapter 6, what the counsel options are. We're now going to cover the different types of release decisions. From a defendant's point of view and his or her attorney's point of view, release on his own recognizance is what they want to have happen. Release on personal is either release on personal or release on own recognizance, ROR. They mean the same thing. And the judge basically says, I'm going to trust that you understand that you've made a promise to this court to return for your next court date. The judge can release on personal with conditions or without conditions. Release on personal recognizance is appropriate if the defendant has no history of failure to appear in court, or very limited history of failures to appear in court. Those are called defaults. And the prosecutor has the defendant's record in front of him or her and can quickly go through and see how many cases has this person failed to show up in court on. And the more of those there are, the higher the likelihood it is that the prosecutor is going to say this is not appropriate for a release on recognizance, this is a bail case, given the repeated failures to appear and defaults. A second factor might be how much at risk is this defendant not to come back to court, even if he or she doesn't have a lengthy record, and that may be, not just a lengthy record, even if he or she doesn't have prior default history with court appearances, if someone is convicted of a crime that has a strong likelihood of being incarcerated if convicted, then that's a risk that the person won't show up. It's an incentive to flee. Take off, become a fugitive. And so that is a factor that the court will take into consideration. But the purpose of bail is not public safety. The purpose of bail is only supposed to be to reasonably assure the defendant's continued adherence at all court proceedings. That's it. Okay. If the defendant is going to be released on personal recognizance, the prosecutor can still ask that there be conditions of release, and typically that would be stay away from the victim, stay away from and have no contact with a victim would be a standard condition of release that the prosecutor would request if a judge were going to release someone on personal recognizance in a case that had victims. It may be that the person has drug and alcohol issues or mental health issues that are prominent enough that the prosecutor may ask that the judge require that the individual get a mental health or substance abuse evaluation and report to probation in order to reduce the likelihood that the person will commit another crime while released on personal recognizance. The second option is bail. The prosecutor can request bail in any case. The decision is the judge's decision. Again, if a judge decides to impose bail, the type of bail is determined by the bail system in the jurisdiction, and bail can be imposed with or without conditions of release. Same thing, if a judge decides the prosecutor requests bail, let's say in the amount of $10,000, and the judge says, no, I'm going to grant bail in the amount of $5,000. The prosecution can then say, we request respectfully that should the defendant make bail, be able to post bail, the conditions of release be that no contact with the victim or any witnesses in the case. And actually, you can't request that. No contact with the victim in a case by the defendant, or witnesses in the case by the defendant. The other thing that could be requested, again, depending upon the circumstances, would be a substance abuse evaluation or a mental health evaluation. Again, wanting to make sure that, to the extent possible, that if the person does post bail, that the risk of reoffending, if it's related to mental health or co-occurring mental health and substance abuse issues, are being monitored by probation on a pretrial basis. Okay. All right. There's no constitutional right to bail. The Eighth Amendment only says that bail cannot be excessive, that it has to be reasonable as related to securing the defendant's appearance. And so there is no constitutional right to bail. A judge can deny bail based upon the factors that are used to make bail decisions in the jurisdiction. I'll share a couple of those with you in a moment that apply here in Massachusetts. If a judge is inclined to release someone only upon bail, the three options depend upon whether it's a cash bail system, a property bond system, or a bail bond system. Massachusetts is a cash bail system. The judge says $5,000, sets bail at $5,000, then $5,000 in cash is what's going to be necessary in order for that person to be bailed out and not subject to continued pretrial incarceration. Property bonds are an alternative to bond up to bail posting in cash, and that could be, well, property might be, for example, I had a case where a mom wanted her son to be bail eligible, and they didn't have the cash, so she said, I'll bring the deed to my property and leave it with the court as a bond, if you will, security for if he doesn't show up, you have the deed to my house. Well, unfortunately for Mom, he didn't show up, and she almost lost her house, but that's a story for another day. And then the other type of bail that you're probably also familiar with is called a bail bond system. And that's where someone is in the business of taking the risk of posting a bond on behalf of a criminal defendant. And in the bail bond system, the bail bondsman actually posts a legal document that says, if this defendant fails to show up, I will pay the court whatever the amount of money is. In a $5,000 bond case that was in a state that allowed bail bond, Typically, the fee that the bail bondsman charges is 10%. So the fee to the bail bondsman would be on a $5,000 bail bond would be $500. The bail bondsman would file that bond with the court. If the defendant didn't show up, the bail bondsman would have to come to court and pay $5,000 until and unless and until the defendant appeared. And that is the incentive for bail bondsmen to go on a search, a desperate and fervent search to find anyone that they've bailed, because they'd be out of business if they had to lose money like that. In a cash bail system, the defendant gets all of the money back, or whoever posted the bail gets all the money back at the end of the case, regardless of whether the defendant is found guilty or not guilty. In a bail bond case, the fee that is paid to the bail bondsman in order to get him or her to take the risk and post the bond that the court will accept, the fee to the bail bondsman is non-refundable. That's his or her fee. Okay, I think I'm almost done. Okay. In serious felony cases, release on personal recognizance is not very likely. Unless serious cases, it's pretty light, depending upon the default history of the defendant. This is national data from 2000, published in 2010. I was unable to get any more current data from the Bureau of Justice Statistics. But obviously, the more serious the crime, the higher the bail amount, the less serious the crime, the lower the bail amount. That just stands to reason. It's not unusual for defendants not to be able to make bail, particularly in a cash bail state like Massachusetts. Not unusual at all. And for that reason, we'll pick up next time on slide 72, looking at the bail bond video and understanding the consequences, very serious and significant consequences. If a judge decides to hold someone on bail and they can't post bail, that is not a good situation for the defendant. They have much higher rates of pleading guilty. They have much higher rates of being convicted and much higher rates of getting sentenced to incarceration. And so it sets in motion a sequence of events that really is not, someone say it's not fair to the defendant, because the reason someone can't be bailed is because they don't have money. Isn't that some way criminalizing poverty? It's treating poverty as a crime. You're taking away my freedom and liberty because I don't have enough money. And there's no way to argue around that. That's exactly what's happening. So we're going to pick up with that next time. Any questions on what we covered today? No? If anybody, Justin, do you have a question?
I did have one. I didn't raise my hand, but I did have one.
Okay, go ahead.
I was just going to ask, the way you said something earlier, you made it sound like judges can deny guilty pleas. Are they able to do that? Or did I just listen to that?
A judge has a responsibility, and we'll talk about this in Chapter 12. The judge has a duty to make an inquiry of the defendant with counsel present, that they understood the guilty plea, that they conferred with counsel, that they were made aware of what the consequences were, specifically that they could be incarcerated, specifically that they could, if they are not a legal, if they're not a citizen of the United States, their guilty plea could impact their immigration status and might even lead to deportation. The judge has a responsibility to make sure that the person who's pleading guilty, with or without counsel present, is making a knowing, intelligent, and voluntary waiver. Therefore, the judge in colloquy will ask a person who's pleading guilty, are you under the influence of drug or alcohol? Are you taking any medication that impacts your ability to make clear decisions? Has anyone influenced you, pressured you, promised you anything in exchange for this guilty plea? So the answer is yes, if the judge is not satisfied that the defendant is making a free, voluntary, knowing, and intelligent plea of guilty, the judge will not accept the guilty plea and will send the defendant back out to talk with counsel.
Okay, thank you.
Yep. Any other questions? Everybody happy? Or at least satisfied? I don't hear anything. So I'm going to assume you're good. If you do have questions, of course, I want you to email me. The quiz on chapter, where are we, 10? The quiz on chapter 10 will be due, let's see, Thursday, Friday, Saturday. Yeah, that'll be posted up by Thursday. So let me know, shoot me an email if you have questions. I hope you're all staying safe and taking good care of all the people you care about. And I'll see you hopefully on Thursday. Thanks, buddy. Take care. Bye.